Voilà, mesdames, messieurs, bonjour à toutes et à tous. Bienvenue dans cette conférence au Collège de France que nous donnera aujourd'hui Lauri Mälksoo. Je vais présenter Lauri Mälksoo en français parce qu'il parle français, même si sa conférence sera en anglais. Lauri Mälksoo est professeur de droit international à l'Université de Tartu en Estonie, comme vous pouvez le voir à l'écran. Il est membre de l'Institut de droit international et de la Commission de Venise du Conseil de l'Europe pour la démocratie par le droit. Et cette année, il était résident de l'Institut d'études avancées à Paris. Et c'est dans ce cadre-là que nous avons pu l'inviter. Lauri Mälksoo, vous le savez si vous avez consulté le site du collège, est spécialiste de l'histoire du droit international, et notamment de l'histoire de la pratique russe du droit international, à laquelle il a consacré de nombreux ouvrages et de nombreuses publications. Et la conférence qu'il s'apprête à nous livrer ce matin est le fruit des recherches qu'il a menées à l'IEA cette année. Donc c'est véritablement du savoir en voie de se faire, comme ça doit être le cas ici au collège, et le fruit du futur livre qu'il y termine actuellement sur l'impérialisme russe en droit international. Alors, Lauri Mälksoo va présenter sa conférence pendant près d'une heure, comme d'habitude, puis ensuite, il a accepté de répondre à vos questions si vous en avez. Vous pourrez vous poser vos questions en anglais ou en français et nous verrons s'il y a besoin de les traduire. Un grand merci en tout cas, cher Lauri, d'avoir accepté notre invitation. Nous nous réjouissons beaucoup de t'écouter sur ce thème passionnant. Donc merci.
Merci. Bonjour et merci aussi pour permettre-moi de parler aujourd'hui en anglais. C'est un peu plus facile pour moi, mais je travaille sur mon français aussi. Peut-être en futur, je serai avoir une lecture en Paris en français aussi. Alors, so the aim of this lecture is to offer some background to Russia's aggression against Ukraine from the perspective of international law and its history. The main question is, where does Russia's war originate from in terms of foundational ideas which have made this war possible? And to visually distract you a bit in this process, I will illustrate my presentation with Russian and Soviet stamps. Stamps are not a source of international law, of course, but they are sometimes little propaganda posters for their issuing state and can therefore be useful illustrations of each era. For me, stamps also have a personal meaning because in Soviet-occupied Estonia, where I grew up in the 1980s, foreign stamps were one of the few permitted windows to the other countries. So as a child, I eagerly followed it when the postman arrived and my father received new stamps from his Czech and East German pen friends. But what can the study of the Soviet period still teach us today? The Soviet theory of international law has actually been studied quite extensively in international law scholarship. But some of this has already been forgotten because the Soviet Union is no more, and thus to know such things does not seem urgent. At the same time, I believe that in certain aspects, the essence of Soviet approaches to international law has still not always been evaluated properly. There is a tendency in parts of the scholarship to acknowledge that the Soviet project was an alternative to Western capitalism and accordingly to neglect or downplay the imperialist features of the Soviet legal political framework. However, one cannot appreciate the essence of the Soviet theories of international law simply as texts, that is, without critically considering the Soviet practice which accompanied these texts. Over the last years, Russia's president has criticized Russia's earlier Soviet leaders such as Lenin or Khrushchev for having made decisions which were detrimental to the territorial integrity of historical Russia, by which he means the Russian Empire. Indeed, Lenin and the Bolsheviks were among the first to formally recognize the right of peoples to self-determination as part of international law. In 1920, Soviet-Russian peace treaties with nations such as Estonia, Latvia, Lithuania, and Georgia prominently included references to the right of peoples to self-determination as ground of secession of these countries from Russia. However, as soon as in 1921, Georgia was nevertheless reconquered by Soviet Russia, so that in this case the Soviet reference to self-determination and statehood following from it, or statehood separate from Russia, was tactical rather than strategic. Apart from nations which separated from Russia after 1917, such as Finland and the Baltic states, the right of peoples to self-determination also had a domestic constitutional dimension, as the territory of the former Russian Empire was reorganized, acknowledging the existence and autonomy of various peoples in the former Russian Empire. Soviet republics, such as Ukraine and Belarus, were created. On 30 December 1922, these Soviet republics, led by Soviet Russia and including Soviet Ukraine, formed the Soviet Union. According to the Soviet constitutions, Soviet republics had the right to secede from the Union, which also finally happened in December 1991, when the Union was dissolved. However, introducing Russia's constitutional amendments in 2020, Putin indicated in an interview that the Bolshevik constitutional idea of allowing Soviet republics to secede from the Union had been a bad idea, a mistake from the Russian perspective. After 1917, to bring and keep the core parts of the Tsarist Russian Empire together in the Soviet Union, the Bolsheviks had to go for major concessions to minority ethnic groups. At least formally, between 1917 and 1922, there were several independent Soviet republics in the territory of former Russian Empire. Several Soviet international law scholars, such as the Georgian Levan Alexidze, held that until 1922, the Soviet republics formed a confederation rather than a federation. To make it attractive for these national Soviet republics to come together, the Russian Bolsheviks had to promise the Soviet republics that they would remain sovereign, even in the federation. Thus, during the whole existence of the Soviet Union, there was a peculiar Soviet legal theory based on which both the Soviet Union and its constituent republics were sovereign states at the same time. Soviet scholars wrote that such a thing, two overlapping sovereignties, was not possible in capitalist countries, but in their view, it was possible in the progressive legal universe of socialist states, first time in history. Only after the dissolution of the Soviet Union did also international law scholars from Moscow, such as Pyotr Kremnev, admit that federalism in the USSR had been fictional, and during most of its existence, the Soviet state was in fact very centralized. In other words, the so-called sovereignty of Soviet republics had been just a slogan. But it also indicates a perennial challenge in Russian and Soviet legal history. Legal statements and theories and the legal reality are not necessarily one and the same thing. In claiming since 2014 revisions to Soviet-era borders, such as in Ukraine, Putin in a way goes mentally back to the pre-Bolshevik Russia, which raises the historical question how the claims of self-determination have been solved if the Bolsheviks would not have come to power in Russia in November 1917. What was the international legal project of the Republican Russia that of the provisional government of 1917. We do have some indications. For example, during the Paris Peace Conference in 1919, the last director of the legal department of the Russian Ministry of Foreign Affairs before the Bolsheviks, not Osip, Mandelstam, who was by then in exile in Paris, published a memorandum in which he discussed how President Wilson's ideas of national self-determination might be applied in the former Russian Empire. In his memorandum, Mandelstam rejected independence claims of Ukraine, the Baltic states, and even Finland. He insisted that the independence of these nations would be against the vital interests of Russia. Instead, Mandelstam suggested that these territories could receive autonomy in the future free Republican Russia. He tried hard to normatively distinguish between the lands of the Tsarist Russian Empire from the Austro-Hungarian Empire, which had also dissolved. At the same time, Mandelstam was unable to tell convincingly what was this distinction exactly. Why did Czechoslovakia deserve independence, but Finland not? Perhaps realizing the limits of his substantive arguments, Mandelstam ended his plea in Paris not to recognize secessions from the Russian Empire with the emotional reference to the Russian soul, quote, the soul of Tolstoy, Pushkin, Lermontov, Solovyov, Gogol, Dostoevsky, and Turgenev, unquote. Mandelstam's rejection of the independence of border states, as they were called, mirrored the ideas of the political leaders of the Russian Whites, such as General Yudenich. Later, in the 1920s, Mandelstam became one of the proponents of human rights in international law and its scholarship. For example, being the rapporteur of the Institut de Droit International's declaration in 1929 on human rights, adopted at the Institute's New York session. Thus, after World War I, being a Russian liberal or Republican did not necessarily imply the rejection of the Russian imperial idea. At least in Mandelstam's case, this was so. Returning to Vladimir Putin, he has also criticized that the border drawing within the Soviet Union was somewhat random. For example, in 1945, the Soviet leader Nikita Khrushchev handed Crimea over from Russia to Ukraine to celebrate 300 years of the Treaty of Pereyaslav, by which Ukrainian Cossacks sought the protection of Muscovy in 1654. Putin is now criticizing that already when Soviet Ukraine was formed in the early 20s, it received some historically Russian territories, such as, in his view, Donbass. Russia now prefers to turn the clock back and tell the narrative of how the Russian Empire got the sovereignty over these territories in the 18th century. However, this cannot, of course, undo the treaties which have existed since 1991 and with which sovereignty went to Ukraine. From the legal viewpoint, Putin's criticism is awkward because in the Budapest Memorandum of 1994 and in the bilateral border treaty of 2003 with Ukraine, the Russian Federation gave assurances and recognized Ukraine's 1991 borders. This change of mind and reversal of policy vis-à-vis Ukrainian borders raises important questions about Russian but also Soviet approaches to international treaty law. This allows me to come to the main arguments in my presentation. What we are seeing is Russia's imperial continuity, only occasionally interrupted and disguised by ruptures and discontinuities. Russia tried a non-imperialist path both after 1917 and 1991, and on both occasions it failed. Today's Putin's Russia takes distance from some Soviet policies, decisions, and practices, in the same way as Soviet Russia took distance from some Tsarist policies, decisions, and practices. Nevertheless, both then and now, the core political idea has remained the same. Russia's approaches to international law have been shaped by the idea that Russia was, is, and has an inherent right to be a great power, in fact, an empire. At times, like in the Soviet Union, the empire may have even used the fierce anti-imperialist and certainly anti-colonial rhetoric in its foreign policy. In different time periods, the desire to maintain the empire has implied the use of different, flexible, and over time also contradictory legal arguments and theories. For example, after 1945, the Soviet Union was rhetorically a proponent of a very conservative approach to the prohibition of the use of force in international law, without exceptions, such as extensive right to self-defense or protecting nationals abroad. However, as the territorial situation changed in 1991 and Russia's borders diminished, the Russian Federation soon moved to a much more flexible approach. For example, extensively endorsing the right for the protection of citizens abroad, but really also not caring about jus ad bellum rules too much in the post-Soviet space. After 1917, Soviet Russia was formally recognizing the right of peoples to self-determination while Sovietizing the newly emerged republics and bringing them together in one union, which in important matters was still governed by Moscow. After 2014, the Russian idea has been the revision of previously established borders and putting forward far-reaching historical claims of where Russia, or at least its sphere of influence, ought to reach in the post-Soviet space. Thus, Putin, although he now criticizes some key decisions of Lenin and Khrushchev pertaining to the territory of the historical Russian Empire, making them almost look like failed leaders in the past, is at the same time still primarily their inheritor in the Russian and Soviet imperial tradition of international law. The main difference is which phase of the life of empire it was, whether it was about to conquer, keep, or reconquer the respective territories. According to whether the empire played offense or defense, it has been either sticks or carrots in Russia's international legal approaches. And let me now zoom in to the problem of state continuity or succession. When I say that there is a certain imperial continuity between Tsarist Russia, the Soviet Union, and now, since Putin, also the Russian Federation, this raises the question, how have state continuity and succession been dealt with after 1917 and then after 1991? In international law, state continuity means that the same state continues to exist, notwithstanding revolutionary change of government, temporary occupation, or loss of some territories. In contrast, state succession means that the old state disappears and is replaced in some rights and obligations by others in their respective territories. For example, after 1917, Finland and Estonia were successor states in certain aspects to the Russian Empire. So, for example, France wanted that Estonia would actually pay its share of the Tsarist era Russian debts. Concerning Russia itself, after 1917, Soviet Russia too had to decide whether it is the same or different state compared to Tsarist Russia. Famously, Soviet Russia rejected Tsarist Russia's debts, unequal treaties with neighbors such as Persia, Afghanistan, Turkey, and others. Lenin had also criticized Tsarist Russia's political essence, calling it the prison house of peoples. Initially, at least, there was an urge to liberate New Russia from the burdens of the past and call it a completely different state. However, in important matters, the Soviet Russian state continuity with Tsarist Russia was quickly established. Initially, Soviet Russia accepted the loss of several territories in the West, first in the Brest-Litovsk peace treaty concluded with Imperial Germany in March 1918. However, already in November of the same year, Soviet Russia renounced the treaty. And we know what happened in Compiègne at the same time. In 1920 to 21, after attempts to militarily reconquer these former Tsarist Russian territories failed, Soviet Russia concluded peace treaties with states which emerged at the former empire's western borders, such as the Baltic states, Finland, and Poland. Nevertheless, this situation lasted just for about 20 years. These were the same former Tsarist Russian territories which the Soviet Union was after when in 1939 it concluded the secret protocols of the Molotov-Ribbentrop Pact with Nazi Germany. In 1920-21, Soviet Russia recognized the Baltic states, Finland and Poland as independent states, but 20 years later, the Soviet Union used the geopolitical opportunity to retake these former Tsarist Russian-owned territories. To do that, Moscow had to violate the treaties which it had concluded during the interwar period with these states. And in other territories affected by the Molotov-Ribbentrop Pact, the Soviets had, during the interwar period, not given their recognition to the changes of sovereignty concerning the former Tsarist territory. For example, the Soviet Union never recognized Bessarabia, which nowadays would be mostly the territory of the Republic of Moldova, as part of Romania, although the League of Nations accepted it as Romanian territory in October 1920. In any case, the Molotov-Ribbentrop Pact became the symbol of what Stalin really thought about the right of peoples to self-determination in the lands of the former Russian Empire. In the East, the Chinese were initially happy that the Bolsheviks were willing to renounce the unequal treaties from the 19th century, like the Soviet Commissar for Foreign Affairs Chicherin proclaimed in 1919. The Chinese hoped that this would include a re-evaluation of the 1858 and 1860 border treaties, regulating the Russian-Chinese border in the Far East, much to the favor of Russia. However, it soon turned out that by proclaiming this rhetorical change for equality in Russia's foreign policy in the Far East, the Bolsheviks did not mean the border treaties or renouncing other territorial concessions, such as the Russian-built Chinese Eastern Railway in Manchuria. During the 1960s, the question of the mutual border became one of the most visible manifestations of the so-called Sino-Soviet split. There was also a claim of Russian-Soviet continuity in relations with Japan. Thus, for example, when celebrating the territorial gains from Japan in 1945, Stalin made a reference to the Russo-Japanese War, which Tsarist Russia had lost in 1905. There were other territorial aspects in foreign policy of the Soviet Union which demonstrated that even with Bolsheviks at the power, there was a continuity with Tsarist Russia, at least in territorial questions and arrangements. For example, Soviet Russia typically protested when Western capitalist powers tried to decide on certain territorial issues, not including the Soviet Union, when before 1917, Tsarist Russia had been involved in the regulation of the status of that territory. For example, the Soviet government protested when Finland and Sweden attempted to settle the issue of the Åland Islands without involving Moscow, referring to Russia's Tsarist-era territorial rights. After 1945, the theory according to which, in terms of international law, the Soviet Union, of course, was the same state as the Russian Empire, became predominant in the Soviet Union. This was facilitated by the fact that in World War II, the USSR gained back several former Tsarist Russian territories in the West, as well as some new ones. For example, Galicia with Lviv or Eastern Prussia. Moreover, to mobilize the Soviet people for World War II, Stalin unleashed the cult of Russian conquests and military heroes in the past, who now were shown in an exclusively positive light as predecessors of the same grand historic mission. For example, in his 1946 History of International Law, Yevgeny Korovin concluded that the Russian absolutism made positive contributions to international law when it, quote, fulfilled historically progressive tasks, unquote, such as gaining access to the Baltic and Black Seas, which were of, quote, vital interest for Russia, or when uniting a considerable part of Ukrainians and Belarusians with the Russian Empire. The later Soviet judge at the International Court of Justice, Fyodor Kozhevnikov, was the most prominent proponent of the doctrine that, notwithstanding changes in the class nature of the countries, the Soviet Union was the same state as the Russian Empire. After 1945, he wrote a history of international law in which he glorified Tsarist Russian achievements and victories in international law and relations, the bottom line being that it was the same state all along. Later, during Khrushchev's thaw, this was one of the few international law questions in which theoretical disagreement was allowed in the Soviet Union. Thus, another Soviet scholar, Mirza Avakov, emphasized a certain discontinuity between the Soviet Union and Tsarist Russia. Nevertheless, Avakov too argued that Soviet Russia was not supposed to give up any of the Tsarist Russian rights, including territorial rights, or was not supposed to pay for the Tsarist Russian debts. Thus, even Soviet authors who highlighted discontinuity in the class nature of Russia since 1917, such as Avakov, maintained continuity about the Russian Empire's territorial rights and international status. The 1947 Soviet textbook of international law, edited by Durdenevsky and Krylov, also inclined to discontinuity between the Soviet state and Tsarist Russia, although of course not renouncing any of the Soviet territorial reconquests or claims. These were quite far-reaching. For example, the authors claimed that the White Sea, the Azov Sea, and the Gulf of Riga were all internal waters of the Soviet Union due to Russia's historical treaties, such as in the latter's case, the Treaty of Neustadt, since 1721. Now, another aspect of this story, treaty law, which I already made some first indications before. There is another interesting continuity here between Tsarist Russian and Soviet Russian approaches to international treaty law in the question of how to liberate the state from uncomfortable treaty obligations. In October 1870, the Russian Empire had caused an upheaval in European politics when, in violation of the Paris Peace Treaty of 1856, it had brought its navy back to the Black Sea. In doing so, the Russian Empire referred to the fundamental change of circumstances, or in Latin, clausula rebus sic stantibus. West European powers insisted that the state could not walk away from treaty obligations like this. The European great powers, including Russia, gathered in London and in 1871 adopted a declaration according to which fundamental change of circumstances is not a valid reason or argument for violating international treaty obligations. Pacta sunt servanda must prevail as an underlying principle with respect to international treaties. And needless to say, almost in contemporary international treaty law, pacta sunt servanda dominates over clausula rebus sic stantibus, or fundamental change of circumstances, in the Vienna Convention on the Law of Treaties of 1969 in Article 62. The London Declaration of 1871 was meant as a clarification of a matter of principle, but also a kind of suppressed criticism with respect to the Russian Empire, which too formally joined the London Declaration, but also got to keep its navy in the Black Sea as fait accompli. Moreover, already in 1886, Russia used the same argument of fundamental change of circumstances in the question of Batumi's earlier treaty-based free port status. And this is a fundamental question, fundamental problem in international law, because treaties are considered the main source of international law. So what can happen to treaties, in fact, tells us a lot about the nature of international law. In the Tsarist Russian doctrine of international law, leading jurists such as Fyodor Martens continued to emphasize the political nature of treaties. Martens wrote that treaties reflected the balance of power, which would inevitably change over time. It was thus a great power, imperial but also potentially imperialist concept of treaty law. For example, in his edited collection of the Russian Empire's treaties with other European great powers, 15 volumes, Martens saw no legal or moral problem in the fact that with 3 partitions, Russia, Prussia, and Austria had partitioned and liquidated Poland as a country in the late 18th century. In terms of international legal technique, the Polish partitions were formalized by treaties. Moreover, conceptually, Martens held that if circumstances changed fundamentally, earlier treaty could be terminated by just one party. And Martens also used the same rhetoric when Russia called other, mostly European nations, to join for the first Hague Peace Conference in 1899. And don't get me wrong, Russia is not the only power who has thought about the fundamental change of circumstances in the treaty law. As a rule, this clausula rebus sic stantibus as argument has been used by revisionist states and their international lawyers. Thus, the German international lawyer Erich Kaufmann, in his well-known monograph of 1911, extensively relied on the Tsarist Russian claims and practice in this regard to prove that clausula rebus sic stantibus was an integral part of international law. Conveniently, Kaufmann's academic study preceded Germany's violation of Belgium's neutrality in 1914. Now, when we move forward to Soviet international lawyers in Russia, then they of course condemn earlier unequal, as they call it, or imperialist treaties. Thus, in their view, there could not be pacta sunt servanda for all treaties all the time, not for imperialist treaties. Moreover, Soviet jurists like Korovin and Pashukanis, they do leave space to the idea that the proletarian state can choose which treaties with capitalist states to respect and which ones to renounce. Essentially, this was already the familiar concept of fundamental change of circumstances in a somewhat modified form with Soviet flavor. In his international law textbook of 1926, for example, Korovin acknowledged that sometimes states use the argument of fundamental change of circumstances to liberate themselves from earlier treaty commitments. This was a part of international law since ages. In a 1936 study on Japan and international law, Korovin referred to an arguable citation of Bismarck, namely that most international treaties were comparable to an agreement between the rider and the horse. Yevgeny Pashukanis added that all law was political and reflected the desired outcomes of those who were in power. The treaties between the Soviet Union and capitalist states could be violated if the class interests of the proletarian state demanded it. Moreover, the Soviet Union could not count, Pashukanis added, that capitalist countries would not violate treaties against it either. Pashukanis explained in 1935 that the power of an international treaty was determined by certain material interests and forces which stand behind these interests. Quote, "The treaty is operational and binds parties until such interests and forces exist," unquote. And of course, I have to think back to 2014 and the annexation of Crimea. After World War II, the concept of fundamental change of circumstances was strongly supported by one of the Soviet international lawyers who specialized in the law of treaties, Vladimir Shurshalo. Shurshalo also understood that there was a continuity between his views and those of Martens during the late Tsarist period. This was good, he wrote. Once again, the support for fundamental change of circumstances for violating treaties and abandoning the principle of pacta sunt servanda was handy in the light of recent Soviet international practice. After the conclusion of the Molotov-Ribbentrop Pact, the Soviet Union violated the sovereignty of 6 smaller states at its western border. When the Soviet Union entered the war against Japan in August 1945, it violated the 1941 Soviet-Japanese Non-Aggression Pact. The Russian-Soviet doctrine that treaties just reflected the balance of power at that moment came very handy to explain away such practices as not a big problem. More than anything else, the Soviet jurists' support for clausula rebus sic stantibus aimed to justify the Soviet reconquest of such territories. Andrei Vyshinsky's edited diplomatic dictionary from 1950 interpreted clausula rebus sic stantibus favorably and brought as an example that when in 1939 the Soviet forces entered Poland, the Polish-Soviet treaties ceased to exist. After World War II, new tropes entered the Soviet literature on international law and treaties. One of them was the claim that the Soviet Union had never violated an international treaty, which was repeated often in Soviet works of international law. Another favorite line was a quote by Winston Churchill in which Churchill said in the British Parliament that the Soviets keep to their treaty promises even if it's against their interest. There was a thought that if one talked about the past in a certain way, what if these other things in the past would cease to exist? They would disappear. Retrospectively erasing from existence is what Krylov and Durdinevsky literally did in their 1946 textbook of international law when they listed European sovereign states on 1st September 1939, but failed to mention the 3 Baltic states in the list. In any case, now that the Soviet borders in most parts corresponded with Tsarist Russian borders, it was necessary to switch to the rhetoric that the most important principle of international treaty law was indeed pacta sunt servanda. Clausula rebus sic stantibus had already done its work for the Soviet Union. This is also why the Soviet Union attributed a big rhetorical importance to the Helsinki Final Act of 1975, because it could be interpreted as recognizing 1945 borders in Europe, or at least recognizing that challenging them militarily was not allowed, was not option. Let me also say a few words on the spheres of influence and their relationship with international law. At least during the interwar periods, Soviet international lawyers criticized Tsarist Russia for having concluded several secret imperialist treaties, for example, with Britain about Iran and Afghanistan, or with Japan about China during World War I. The sentiment was that the Soviet Union was a different kind of state and rejects such policies. However, then 1945 came with hegemony over Central and Eastern Europe beyond the Soviet interwar borders. Then Soviet scholars developed the concept of socialist international law, highlighting the importance of the Warsaw Pact and the Council for Mutual Economic Assistance, or COMECON. The political significance of the theory of socialist international law became apparent when the USSR suppressed militarily the uprisings in the socialist camp in Central Europe, in Hungary in 1956 and in Czechoslovakia in 1968. On both occasions, leading Soviet scholars such as Yevgeny Usenko after 1956 and Grigory Tunkin after 1968 referred in the Soviet Yearbook of International Law to the theory of socialist international law to justify the Soviet military interventions. The main idea was that there was a special kind of international law in force between socialist states, with principles such as proletarian internationalism. Naturally, as the oldest socialist country, the Soviet Union saw itself as the older brother and the superpower in the socialist camp. Socialist international law, in the view of these Soviet scholars, included not only rights, but importantly also obligations towards each other. Thus, the Soviet Union was obliged to intervene militarily if the regime in one of the socialist states was in danger, and the recipient state was obliged to accept that intervention, if you will. Such a theory was not compatible with the United Nations Charter. Contemporaries also called the application of the theory of socialist international law in Czechoslovakia the Brezhnev doctrine. Scholars in the West, particularly in Germany, such as Boris Meissner and Theodor Schweisfurt, or Edward McQueenie in Canada, but also Moscow state rivals at the time, such as Mao Zedong's People's Republic of China, they understood well and criticized accordingly the hegemonic and imperialist nature of the Soviet theory of socialist international law. Let me now wrap up my thoughts, and then we can maybe later have a little discussion if you want. Turning to our own time, then Russia's constitutional amendments of 1st July 2020 emphasize state continuity, although in the same way as during the Soviet period, they also simultaneously refer to state succession. The respective Article 67(1), para 1 of the Constitution now stipulates that the Russian Federation is the state successor of the USSR on its territory, and also state successor, and in parentheses, continuator of the USSR. Thus again, like during the Soviet period, Russia wants to be the same state as before, but in a way that creates flexibility. Russia can claim to be the same state as the Russian Empire and the Soviet Union, except when it does not want to be, for example, concerning negative consequences of this continuity from state responsibility or some previous agreements. Again, the Russian lawyers' voices which would have preferred a certain discontinuity with the Soviet period. Think of what the Soviet period did to property rights in Russia that had only been emerging in the early 20th century. These lawyers remained a tiny minority. For example, the Constitutional Court judge Konstantin Aranovsky in a separate opinion in 2019. But even the Russian Federation itself, claiming to be still the same state as the Soviet Union, and having concluded all the treaties like the border treaty with Ukraine in 2003, does not now prevent President Putin to claim that the Soviet-era border with Ukraine needs to be adjusted, that it already has been adjusted in his view. Like with Martens and with Pashukanis, agreements are primarily political and reflect the balance of power at each moment. It is not surprising that, for example, Georgy Velyaminov, one of the leading Russian international lawyers of the older generation who has been active since the Soviet era, in 2014 justified Russian annexation of Crimea and Russia's violation of treaties which preceded it, you already guessed it, with the argument of clausula rebus sic stantibus, fundamental change of circumstances. Thus, to wrap up, when we speak of the intellectual origins of Russia's war against Ukraine in the context of international law, they have a lot to do with the eternal recurrence, to refer to Kundera, of something. What is it that recurs eternally here? It is our old acquaintance, the Russian Empire, the Russian imperial idea. There is a continuity in Russia and the Soviet Union of using international law and legal arguments for the justification of imperial conquests and status, but mostly also based on the historical idea that somehow most of this was Russian in the past to start with. Ultimately, this is also one of the main reasons why the initially good faith experiment of including the Russian Federation in the Council of Europe in 1996 to 2022 was meant to fail in the end, when the imperial idea proved stronger than anything else, then internationally monitored human rights or democratic standards do not have a great chance to prevail. A liberal empire, as Andrei Mandelstam in 1919 and after 1991, for example, Anatoly Chubais have proposed it, is an oxymoron, at least in the Russian historical circumstances. Russia will never be liberal as long as it wants to be an empire. The empire violates international treaties with its neighbors, which seceded from it in the past, and it continues to feel the phantom pain towards them and concludes that the separation was unjust or unnecessary or simply dangerous. This happened at Russia's western border in 1939-1940, and now again in Ukraine, at least since 2014, but especially 2022. Thus, when the war against Ukraine will at some point hopefully come to an end, and the relations between Russia and other European countries would have to be cautiously reimagined, the test question for any democratic partners in future Russia will have to be, do you see what the empire has done, at least to other peoples and states? If this is not understood, the whole region is cursed to again and again live through tragic and violent circumstances, which we are currently witnessing in Ukraine, and international law in Russia will not speak truth to the power, but will continue to be a handmaiden of imperialism. I thank you for your attention.